Good evening. Happy Wednesday. I have been lately leaving for work at 7 in the morning and getting home from work at 8, 8:30 at night. And today I decided, you know what? I'm gonna only be gone for about 10 and a half hours today instead of my normal 13 or so. So had a little extra time, and I really liked some things I saw this week coming out of a few cases in the Wallace versus Las Vegas Metropolitan Police Department. I haven't been covering it because it's essentially Decastro versus Las Vegas Metropolitan Police Department round two, and why cover the same stuff twice? Chili's what pants? Chili is drafting apparently the pleadings for both parties, for himself and for Wallace. So on one side of the V, you've got Chili, and on the other side of the V, you've got the same attorney. I can't remember his name right now. Well, let's look at it. Here's a motion to strike. Craig Anderson, and the same law firm, Marquis Arbach. So you have the same attorney. Well, I use the word attorney very loosely. You have the same attorney on both sides. You have the same person drafting the pleadings on both sides of the V for both cases. So I haven't really been covering it, but there has been a new and interesting wrinkle. So we're going to cover that. We're going to go over an order in. This is Castro versus Wagner. And then I'm going to talk a little bit about soliciting a trespass and why that makes no real sense. So this one was following the standard kind of procedures that happen with any Chili claim. You get down to your motion to dismiss. Everybody was supposed to file a response to the motion to dismiss by the 31st. So Wallace still has time, obviously. But then we get this, and this has sparked a bit of hype. So let's take a quick look at this motion to preclude Jose Decastro from practicing law without a license. Now, I know a lot of you believe that Chili's going to get charged with something. I know you believe that, and I know you believe that somehow this is going to result in something magical happening to Chili. This is a well written pleading, and in this pleading, the attorney makes a good argument that Chili is in fact practicing law without a license. However, the question is, what does the court have to do at a minimum to preserve the integrity of the court and to really, that's it. What's the minimum to preserve the integrity of the court? So this is one of the cases that was cited by the defense attorney in his motion to preclude Chili Decastro from practicing law without a license. You'll notice that this was an Arizona case, but 6 of one, half a dozen of the other. Same circuit. This is a district court case. Nothing like this is ever going to get up to the. Thank you. Just in case you guys thought the roosters had gone to bed, something like this would never get up to the appellate level. So what happened in this case? In this case, the father, Amon Sproul the first, or senior, or whatever he called himself, maybe just Amon Sproul, was accused by counsel of preparing the pleadings, the responses, the the various documents for his son, Amon Sproul II. I swear to God, not a single crow until I start recording. Not a single crow. You guys are assholes. Bunch of assholes, I swear to God. Anyway, so the defense attorney made the same basic arguments that our erstwhile attorney, Mr. Anderson, is making in Wallace's case, and this is the order of the court. Pending before the court is defendant's motion to preclude Amon Sproul from practicing law without a license. Defendants also request court to preclude Amon Sproul II from litigating on his own behalf. For the reasons discussed below, court grants defendant's motion to preclude Amon Sproul from practicing law without a license. So what happens in here? There's the analysis. Is he doing it? Conclusion. For the reasons stated above, Amon Sproul will not represent Amon M. Sproul II in this matter. That's it. That's it. That's all that happens. So if you're anticipating the court going after Chile or issuing some sort of a contempt order, it's not going to happen. Any charges that are going to be brought, that my understanding is that in Nevada, the Nevada State Bar will handle issues of attorneys practicing law without a license in Nevada. So like if I went and I tried to practice law in Nevada, the Nevada State Bar would be like, hey, John, you're a dumbass. We're going to sanction you. And then all of a sudden they would notify California State Bar, and then I'd be facing some serious consequences for practicing law without a license in another state, yada, yada. But as far as criminal charges for practicing law without a license, that has to go through a DA. And the allegations that the defense attorney is making are fun, and they're kind of circumstantial evidence. Like, for example, look, this is like this, and this was copied verbatim, and this was almost identical, right? So you have all these almost identical things. But here's a little clue for folks out there. If you look at 90% of my pleadings, they're identical to another pleading that either I've made or another attorney I've worked with has made, because you don't reinvent the wheel. You find another pleading that is asking for the same relief that you're asking for, and you copy the format of it. You might, if there's a on point legal arguments, you might copy the legal arguments from them and just substitute in your own facts. So this isn't the smoking gun. This is the opposite of a smoking gun. This is, as far as any like DA is concerned, this is going to be something like these two people both got the same. They both got the same template that they drafted their lawsuit from. So that's going nowhere fast. I love to break people's hearts with that kind of stuff, but it's going nowhere fast. Now, other things going on here is there's a motion to strike the complaint. And this motion to strike the complaint is basically arguing that because the complaint was drafted by an unlicensed person, that it's an improperly filed pleading and therefore it should be struck. Now, is the court going to strike this pleading? Well, there's also a motion to dismiss. So the motion to dismiss is a completely separate topic. A motion to dismiss is different than a motion to strike. A motion to strike basically removes the pleading but doesn't otherwise rule on anything of substance. It's just that pleading never happened. Is the court going to strike this pleading? Probably not. I would, if I was going to bet on it, if I had to go to Vegas, I would bet that the court will not strike the pleading, because again, it could just be a template that that Wallace applied his own facts to. Now, here's something funny, and I don't know exactly why the court is doing this. Maybe it's just my misunderstanding, but this is kind of funny. The court is ordering some sort of a briefing about Klingel versus Eikenberry and Rand versus Rowland. Now, I have never represented anybody in federal court on a criminal matter. I've never been defense counsel against a prisoner who was filing pro se, but I've read both of those cases, and both of those cases deal with pro se plaintiffs who are in prison, and they are the court is required to make sure they have notice of the Rule 56 summary judgment. And obviously there's no summary judgment motion. And to the best of my knowledge, Wallace is not in prison. So I don't know why the court is saying this. Unless Wallace is in prison and I just don't know about it. If he is, mea culpa, but I have not heard that he's in prison. Last I heard, he was free and he went to file this on his own, or he went with Chile and Chile went in to file it for him. But anyway, that's a long run around on that. So I don't think. Oh, the esteemed pro se offices of Stout, and Stout are here. Well, the moment that I go to Stout, and Stout for legal advice is probably the moment where I suck start a 45. So sorry, Mr. Stout, I don't value your advice, sir. Anyway, so the next thing we're going to talk about is this. This is a beautiful piece of work, and I normally would not read it, but this is just beautiful. And the court does things in here that are very. So this is Decastro versus Wagner. This is the order on Decastro's motion for a protective order and for sanctions. And I had said that Chile wasn't going to get the sanctions. You're not allowed to be smarter than me, says me. So you're all right, Merb. Oh, don't want you to learn. Yeah, okay. I have to tell you, Mr. Stout, that I'm not here to entertain you in my comment section, and I don't value at all what you attempt to do by playing attorney and misleading people. And we are not in a competition, because I am an attorney and you're not, and I am qualified and licensed to talk about these things and you're not. So I would caution you, Mr. Stout, that you're not very welcome here. You're tolerated but not welcome. So let's not try to get into any pissing matches. You beat your dick, sir, and have a good night. So this order was very well written, and because it was so well written, and because it did address nuance so well, and I thought the court was gonna deny the motion for sanctions as far as sanctions were concerned, but the court was going to not necessarily grant the protective order, but issue some order delaying Chile's response to the second set of discovery until after a Rule 26F discovery, whatever you want to call it, discovery conference was held. So, but the court did a much more elegant solution, and I loved it. So, pursuant to local practice, all non-dispositive. What non-dispositive means is it doesn't actually settle any issues that are actually of merit to the case. So, something that would be like a motion to like determine whether or not a contract was valid or something, that might be dispositive to a case because, well, if that contract is valid, then moving forward, you can no longer argue that that contract is invalid or something like that, or a motion to for summary judgment, or a motion to strike, or a motion to dismiss. Those are going to be dispositive because those are taking issues, tribal issues, off the table. A discovery motion is one of many non-dispositive motions. It doesn't end the case if you lose your discovery motion. That's what dispositive means. It doesn't take any issues that are tribal off the table. So all non-dispositive motions in this pro se civil rights case have been referred to the magistrate. In addition to the two dispositive motions filed by defendants, those two dispositive motions are one defendant has a motion to dismiss, the other defendant has a motion for summary judgment. Plaintiff has filed a non-dispositive motion that seeks a protective order from discovery requests propounded by defendants. For the reasons below, plaintiff's motion is denied. Background. So here's the start of it. The magistrate is going to give us a background. Now, the court doesn't have to give us a background. This is a discovery motion. The court doesn't have to give us a background to rule on a discovery motion, but the court's going to give us a background, and we're going to explore why potentially the court gave us this background. On April 13th, 2022, plaintiff Decastro, a resident of California, paid the filing fee and initiated his civil rights action against multiple defendants, including the City of Ironton Chief of Police and 4 individuals and a Jane Doe employee. All right, so the first thing the court is setting up is that more than a year ago, on April 13th, 4/13/2022, this order was filed sometime around a year and 3 months after this was filed, and the initial discovery conference is supposed to be somewhere within months after filing, not more than a year, right? So that's the first thing the court is addressing with this background. Plaintiff also named the City of Ironton. 2 groups of defendants, hereinafter the county defendants and city defendants, filed separate motions to dismiss and for judgment on the pleadings. That's the motion to dismiss is a 12B. I think it's 12B. It wasn't a 12B6. It was a different 12B. And the other one is the summary judgment, i.e., assuming that everything that the defendant stated is true, he still loses. When plaintiff failed to file a timely response to either of those motions, a court filed orders to show cause with deadlines of July 22nd and August 11th, 2022, respectively. So plaintiff has failed to follow the timing. Plaintiff did not respond to the first order to show cause, but responded to the second on the deadline of August 11th, 2022. So he completely blew one off, and he filed a response on the second one. In his response, he states that before July 27th, he received nothing from either this court or the defendants, even though his postal address has remained the same throughout the case. The court accepted the response in satisfaction of both show cause orders and permitted the plaintiff another 30 days until September 15, 2022, to either respond to the pending motions or file an amended complaint. So what the court is saying here is, we were nice to you. You effed up. You effed up again. Even though you effed up twice, we gave you another chance. On that deadline, plaintiff filed an amended complaint that appears to narrow the list of defendants by eliminating all claims against the 3 county defendants, including Lawrence County Mayor Chapman and Jane Doe, as well as one of the city defendants, the City of Ironton. In his amended complaint, plaintiff alleges he's a videographer, vlogger, and a civil rights activist who's been video recording, publishing his recordings edited and unedited on media platforms such as YouTube, Facebook, Instagram, and the like since approximately 2020. Plaintiff generally alleges the defendants violated his First, Fourth, and 14th Amendment rights under 42 U.S.C. 1983, beginning with an incident on Tuesday, March 29, 2022, when plaintiff was arrested by 4 officers at the Ironton City Hall. Plaintiff alleges the arrest was unlawful and defendants improperly demanded his social security number and unlawfully seized and damaged his personal property. Plaintiff states that the criminal case, quote, related to the unlawful arrest is still ongoing, end quote. His amended complaint seeks punitive and exemplary damages for $1 million against all named defendants jointly and severally. Is he going to get that? No, he will not. On September 22nd and 29, 2022, defendants filed new motions to dismiss and for judgment on the pleadings in response to the amended complaint. When plaintiff again failed to timely respond, the court again issued 2 orders to show cause, listing deadlines of November 17th and November 30th, 2022. After plaintiff failed to respond to either order, on December 6th, 2022, the court terminated this case and entered judgment for defendants. The next day, on December 7th, 2022, again, untimely, the court's pointing out, Decastro has been untimely. Plaintiff moved for leave of court to further extend his time to respond to the motion for judgment on the pleadings, citing excusable neglect and asserting he had, quote, not received 2 of the 3 orders to show cause, which resulted in delayed responses, end quote, and incorrectly claiming that he had attempted to respond, quote, on Monday, December 5th, which is the deadline for responding. Contrary to plaintiff's assertion, there have been 4 orders to show cause, and the deadline for the single show cause order for which he admits receipt was November 30th, 2022, not December 5th, 2022. Again, late, failing to meet the timelines. Both the city and county defendants strongly opposed plaintiff's motion to extend time and implicit request to reopen this case, noting the large number of documents they've served on plaintiff at the address listed of record and simultaneously served via email by the city. Counsel for the city defendants also filed an affidavit confirming that no return mail has ever been received. As previously noted, and consistent with the defendant's representations, i.e., the defendants aren't lying. The defendants aren't lying. No mail has ever been returned to this court, proving valid delivery by the U.S. Post Office. At any rate, whatever issues plaintiff allegedly experienced with prior service presumably have been fully resolved by this court's April 11th, 2023 grant of his request for electronic filing rights. Oh, oopsie effing doodles. Oopsie effing doodles, sir. Both city and county defendants cited well-established case law, i.e. they have a really good case, holding that a litigant's pro se status does not excuse his compliance with deadlines, and noted that this case has been much delayed by plaintiff's conduct, suggestive of gamesmanship. Well-established! It's really good case law. That's really good. Now, the fun fact is the judge who is handling dispositive motions is going to read this. He will read this, or she. He, she, it, whatever. But giving plaintiff benefit of the doubt. Again, you effed up, and we gave you leniency. We gave you the benefit of the doubt. We were kind to you. We were gracious to you. The court vacated its judgment and it granted him an extension of time to respond to defendants' pending dispositive motions. Plaintiff then waited until the extended deadline of January 13th to file his joint response in opposition to these motions. Plaintiff's December 7th, 2022 motion for extension of time had attached a copy of what looks like the same response in opposition, but the court's order granting his motion for an extension of time did not direct the filing of the response at that time. So the court is noting, like, look, you had your opposition ready to go. It was ready. You attached a copy of it to your motion for an extension of time. And you still waited to the very end, to the last possible day to file it. The court notices these things, sir. Defendant's dispositive motion remained pending before the presiding district judge. However, on May 15, 2023, plaintiff filed a non-dispositive motion for a protective order that has been referred to this magistrate judge. On May 22, 2023, and on May 25, 2023, the city and county defendants filed responses in opposition to plaintiff's motion, to which plaintiff has filed separate replies. So this court spent a lot of time and energy going over how gracious the court has been to Chile. And they did it for a purpose. Analysis of plaintiff's motion for protective order. Federal Rule of Civil Procedure 26C governs protective orders and grants discretion to the court to fashion discovery in a manner, quote, to protect a party or person from annoyance, embarrassment, oppression, or undue burden or expense. Plaintiff seeks a protective order to, quote, stop defendants from participating in premature discovery that violates the federal rules of civil procedure in order to harass and or unnecessary burden plaintiff to keep personal information confidential and any other relief that this court deems proper. Somehow, I don't think the court deemed any relief proper. Plaintiff states that on March 8th, 2023, county defendants Chapman, Lawrence County, and Jane Doe initially emailed written discovery requests. Plaintiff responded by objecting mainly on procedural grounds. His procedural grounds were, this is 6. Plaintiff's motion complains the requests were improperly served by email, even though the email states that another copy is being served by mail. Ooh, buddy. Courts don't like, first of all, courts don't like discovery motions. Courts abhor discovery motions. Lawyers are argumentative assholes, and we love to argue discovery. And we argue the most picayunish details of discovery. And we argue niggling little trivialities of law as rationale for why we should not have to respond to someone else's discovery request. And quite frankly, the courts are tired. They're sick and tired of our bullshit. They are tired of our bullshit. That's why we'll get to it, but that's why the judge in this case has a standing order about discovery. That's why the magistrate in this case has a standing order about discovery. That's why there's a local rule in this district about discovery and how motions for discovery have to be handled, because they're tired of our bullshit. The point of discovery is not to beat the other side over the head, and it's not to play games. It's to make sure that everybody has the same information. That way, you might get a settlement. You might save everybody a lot of time and trouble if everybody knows what everybody has. That's why there's a requirement under the Federal Rules of Civil Procedure for you to disclose. You've got to disclose everything like right out the gate. So the court's tired. That's why there has to be a settlement conference or a discovery conference right at the get. It's supposed to be at roughly the beginning of the case. Everybody gets served. The court's going to set a discovery conference to make sure everybody's on the page about what is expected as far as discovery is concerned, and everybody makes their initial disclosures. And let's all move this thing to its resolution. So the courts look disfavorably on procedural grounds for objecting to things as far as discovery is concerned. They will look for ways to get around that procedural issue to be like, dude, give him the freaking documents he's asking for or whatever. And immediately, threatening sanctions. Courts also don't like it when you threaten sanctions because basically you're saying, I'm going to go get my daddy to beat your ass. And the court's like, I'm not here to fight for you. I'm here to be neutral and to basically referee this dispute between the two of you. You don't get to choose when I wield my power. Courts don't like that. It is irritating to courts. Did you mean to send me interrogatories, especially these ones? Snarky emails, they're the best. Courts dig them. Courts dig them. Like, this guy's an asshole. Sending interrogatories without leaving the court before the 26F meeting is improper. And these questions are mostly requesting things that will be in my initial disclosures for things wholly inappropriate, especially given my claims. Should I disregard these? Or is there any reason why I shouldn't file a motion for sanctions? I'm considering doing exactly that. Were you aware you're out of bounds? I mean, that's just snarky and being an asshole. You're not doing what you're supposed to do, i.e. making a good faith attempt to meet and confer to resolve these discovery issues. Now, in responses, what did the defendants do? The county defendants promptly responded, acknowledged the procedural error, and instructed plaintiff to disregard the requests. I was mistaken in my belief that a Rule 26F report was completed in this case. After reviewing the document, I realized it has not been completed. Please disregard this first set of written discovery that I've sent. I will send it to you once more when the Rule 26F report is filed. Now, did the attorney who got that email from Decastro want to stick it into Castro's ass and break it off? Oh, hell yes, he did. Hell yes, he did. But did that attorney do that? No. The attorney did not do that. Why? Because the attorney knew all this shit was going to go in front of the judge. The attorney was like, oh, you're going to be the asshole? Great. I will let you be the asshole. You be the asshole. I'll be the good guy. We'll see which way the judge breaks out on this. On April 11th, 2023, plaintiff received a similar set of written requests. How the court knows that it was a similar request, I don't know. Because Chile never showed anybody what these requests were. So, how did the court know? I don't know. Plaintiff states that he found the city defendant's request to be less substantively objectionable, but still objected because they were served before a Rule 26F meeting. Rather than communicating the objection, however, he decided not to respond at all because it wasn't worth typing up a reply letter. You have an obligation to do a good faith meet and confer. The antithesis of a good faith meet and confer is not responding at all because it's not worth typing up a reply. Defense counsel politely, the court is like really painting this on. The defense counsel politely, that is in opposition to what Chile was, an asshole, defense counsel politely contacted plaintiff more than a month later to ask about the lack of responses. Can you please advise on the status of your discovery requests and when can we expect your responses? As with the county defendants, plaintiff immediately replied with a threat of sanctions. The tone of plaintiff's email speaks for itself. My God, the ineptitude is staggering. Wait, I'm sorry, Chile. Whose ineptitude? Oh, excuse me. I was reading. You won the Dunce Cap of the Day award. Fucking irony, dude. Like, this guy bathes in irony. You're not getting away with it. But wait, they are. Especially with lawyers like you. You're going to make sure that they won't get away with wrongfully arresting me. Did you mean to send me interrogatories, especially these ones? Sending interrogatories without leaving the court before the 26F conferences and property. And these questions are mostly requesting things will be in my initial disclosures or for things wholly inappropriate, especially given my claims. Should I disregard these, or is there any reason why I shouldn't file a motion for sanctions? I think I'm going to file a motion for sanctions. I won't rest until my good name is cleared. Well, it's not cleared yet, motherfucker. Remaining professional, there was, I should say, past tense, there was a wee dram of whiskey in my drink, and so I am slightly lubricated at this point. So if I slur, well, I'm just speaking in cursive, and it's elegant. That was a quote from Dean Martin, I think. Remaining professional. On May 9th, 2023, defense counsel asked plaintiff for times that would work in a valid phone number. Apparently, the phone number that Chili puts on his pleadings is not valid. To meet and confer regarding a Rule 26F discovery plan. We are happy to schedule a Rule 26F conference. Please provide us with the times in the next 2 weeks that work for you and a phone number to reach you, and we can confer regarding a discovery plan. Attaches Judge Barrett's discovery plan form that we can discuss. If you prefer to exchange suggestions on the discovery plan via email, let us know. Thank you. Again, this attorney who wrote this had just read this bullshit. Did this attorney want to say, Chili, you're a fuckwit? Yeah, he did, or she did. Did they? No. Why? Because they knew the judge was going to read it. Son. Oh, what's that guy's name? You played yourself. Plaintiff, again, chose not to respond, instead moving for a protective order 6 days later. In his motion, he argues that courts have the authority to stay discovery while dispositive motions are pending. Based on that authority, plaintiff asserts there will be no Rule 26F meeting until after the dispositive motions are decided. Yet plaintiff has never sought a stay in this case, which has now been pending for more than a year without a preliminary Rule 26F meeting. Oh my. In one of his reply memoranda, plaintiff asserts that he is, quote, is willing to participate in this action, end quote, but that, quote, scheduling a Rule 26F meeting prior to the pending motions being resolved would be wasteful. Ironically, he accuses defendants of game playing or of sheer incompetence. I don't want to mince words. The court here just said that Chili is game playing and is exhibiting sheer incompetence. The court could not be more direct without possibly violating some sort of canon of judicial, whatever they call it, judicial canons, where you gotta be polite. Man, that is rough. You're playing games and you're incompetent. I'm a 20-year constitutional law scholar, an incompetent one. Oh, just get wrecked, son. Plaintiff's motion is denied first because it's moot. This is where I really start appreciating the level of thought the court put into this. So plaintiff's motion is denied first because it's moot. But was it moot? Let's read on to find out. Once alerted the plaintiff's procedural objection to participating in discovery prior to a Rule 26F conference, counsel for both city and county defendants made it clear they agreed that no responses to the request would be required before that conference. But did they? I know the first one withdrew them, but the second one did not. So did they? Did they make it clear? Did they make it clear they agreed that no responses to the request would be required before the conference? Did they? I don't think they did. But that's what the court ruled, and it cleared up two problems at once. So that's awesome. The court really handled this cleanly. Counsel for the county defendants explicitly told plaintiff to disregard the first set of written discovery that was sent because it would be sent again when the Rule 26F report is filed. Counsel for the city defense responded to plaintiff's pejorative email by requesting plaintiff's cell phone number and dates for a Rule 26F discovery so that discovery could proceed. A request the plaintiff flatly ignored. See, you see the little game the court played there? The court couldn't say that the city defendants responded to plaintiff's pejorative email, and the court didn't have to put that particular adjective in there. But the court did, so Chili should be aware of that. But the court couldn't say expressly where the the city defendants clearly told Chile that no response would be due before the conference. Plaintiff's reprehensible, again, another adjective, reprehensible conduct provides the second basis for denying the motion. So not only do you lose, but you lose twice. Under the federal rules of civil procedure, a motion for a protective order must include a certification that the movement has in good faith, that's important, in good faith, conferred or attempted to confer with other affected parties in an effort to resolve this dispute without court action. Plaintiff's motion contains a rote statement that he attempted in good faith to confer with defense counsel to resolve this dispute, but has been unsuccessful. Based on the record, that statement is patently, clearly false. Along with the reference federal rule of civil procedure, the Southern District of Ohio has published local rules, the Southern District Ohio Civil Rule 37.1, entitled Consultation Among Counsel, Informal Discovery Dispute Conference, provides objections, motions, applications, and requests relating to discovery shall not be filed in this court under any provision in Federal Rules of Civil Procedure 26 or 37, bold, underline, unless the parties have first exhausted among themselves all extrajudicial means for resolving their differences. Extrajudicial means without involving the court. After extrajudicial means for the resolution of differences about discovery have been exhausted, in lieu of immediately filing under Federal Rules of Civil Procedure 26 or 37, any party may first seek an informal telephone conference with the judge assigned to supervise discovery in the case. So this is permissive, not mandatory. Last but not least, U.S. District Court Judge Michael R. Barrett presides over this civil action with non-dispositive matters referred to the undersigned magistrate judge. Section D of Judge Barrett's standing order regarding discovery motions states, in all caps, this court does not permit discovery motions, i.e. motions to compel or motions for a protective order regarding discovery disputes, unless and until counsel use the following procedure. Counsel must, mandatory, first attempt to resolve disputes by extrajudicial means required by Southern District Ohio Civil Rule 37.1. Bold, underline, this court defines extrajudicial means as requiring counsel to try to resolve the matter both in writing and telephonically. If counsel are unable to resolve the dispute between themselves, then they must, mandatory, contact the courtroom deputy, Kirsten Zeller, and a telephone conference with all counsel and the court will be scheduled as soon as possible. Emphasis added. The undersigns, i.e. the magistrate's standing order, similarly states that this court, quote, does not allow motions relating to discovery until an informal discovery conference is held. An informal discovery conference with court may be scheduled only after, underlined, the parties have exhausted, quote, underlined, all extrajudicial means of resolving, end quote, their dispute. See Bowman General Standing Order on Civil Procedures, emphasis added. The undersigned standing order applies to cases referred under 28 U.S.C. 636b, as well as to cases in which the parties have consented to a final judgment by a magistrate judge under 28 U.S.C. 636c. When a presiding judge's procedures differ in a case referred under 636b, the parties must comply with the district judge's procedures. So I don't know really why she's going into hers, but the magistrate judges or the district court judges' procedures are the controlling ones. Plaintiff's conduct here violates Federal Rule of Civil Procedure 26C, Southern District of Ohio Rule 37.1, and the standing orders of both the presiding district judge and the presiding magistrate judge. Plaintiff's initial response to the county's discovery request focused less on dispute resolution than on its threat to move for sanctions, i.e. there was no attempted dispute resolution. After the county's counsel responsibly acknowledged the procedural error, directing plaintiff to disregard the first set of written discovery requests until the Rule 26F conference, no dispute remained. So, counsel for the county resolved the dispute single-handedly. It also remains unclear whether plaintiff's amended complaint continues to seek liability against counsel defendants. In any event, plaintiff made no further attempt to communicate with opposing counsel for the county defendants before filing his motion. Plaintiff's failure to communicate with counsel for the city defendants is even more egregious. After receiving discovery requests from that group of defendants, plaintiff admits he, quote, did not bother to respond, end quote, at all. When counsel eventually asked about what they perceived to be overdue responses, plaintiff attacked. He attacked with his words, with a pejorative and extremely uncivil email in which he again threatened sanctions. He ignored counsel's reasonable follow-up request to provide a telephone number or dates and times for a Rule 26F meeting so that this case might proceed. Rather than notifying counsel of any remaining dispute, again, there is none, he moved for a protective order. And despite seeking a protective order on grounds that discovery requests are duplicative of information to be provided in his initial disclosures, plaintiff refuses to participate in a Rule 26F conference or to provide those initial disclosures. Yeah, so I'm going to give these to you in my disclosures, but I'm not going to give you my disclosures. That's helpful. In his reply memoranda, plaintiff maintains that he was, quote, unaware, end quote, of the court's standing orders and offers a cursory, quote, apology. He offers a cursory, quote, apology. The court is saying there that wasn't an apology, that was an apology. It wasn't an apology, it was an apology. That is brutal. Brutal. He then blames defendants for their alleged failure to request a meeting with the court's courtroom deputy. He then blames defendants for their alleged failure to request a meeting with the court's courtroom deputy in compliance with the standing orders. He suggests that this court should overrule defendants' objections as, quote, moot, end quote, based on that alleged noncompliance. But as the party requesting a protective order, it was plaintiff who had the obligation to contact the court before filing any discovery-related motion. Underlined, and to be clear, plaintiff had no right whatsoever to contact this court prior to fully exhausting all extrajudicial efforts to resolve his dispute, bold, in good faith. Meaning that he must communicate more than once in writing with opposing counsel about the details of any dispute and pick up the telephone if he cannot resolve the issue through written communications. Based on plaintiff's course of conduct to date, he will be ordered to immediately contact defense counsel for both city and county defendants in writing to provide dates and times for Rule 26F telephonic conference. If all parties agree to delay the exchange of initial disclosures under Rule 26A, or if they wish to delay substantive discovery until the presiding judge rules on pending dispositive motions, they may express their agreement in their jointly filed report. That said, the parties are not excused from their obligation to meet and confer to file a 26F report. So this is a bunch of work for Chile, who does not get paid to do initial disclosures. And Chile is going to find very quickly that any initial disclosures provided by the city and county are going to be completely ever fucking useless to his case, which he has none. And so he should really not have filed this in the first place. So he's going to have to produce a whole lot of bullshit. They get paid by the city and county to produce a whole lot of bullshit that Chile's not going to be able to use. Chile's case is not going to be any better or worse after having done this. He still has a nothing burger case with nothing to proceed on. And it's not up to him whether or not they delay the exchange. They have to agree. The parties, if all parties agree to delay the exchange. So if the city and council want to be like, fuck you, buddy, we're getting our disclosures and we're marching down this road toward discovery, guess what, kids? We're doing it. And Chile's going to learn how fun it is to play an attorney when you actually have to respond to discovery. And if Chile does not substantively respond to discovery or fails to substantively provide the initial disclosures, he is going to find himself on the bad end of a motion to compel. The bad end, i.e., this court is already now jaded against him based on his actions in this case, so it's not improper. The court is basing its opinion on his actions in this case, and he has already set him up. He's already been set up to be a liar. So whatever he says, whatever he declares, falso in uno, falso in omnibus. Chile is now branded a liar by this magistrate judge. You're a liar, dude. You're a game player. You're a liar and a game player, and you don't work well with other people. Anything you say now is not worth the shit my chickens have crapped all over this deck. You're done, son. You're fucking done, son. As a third basis, as if 2 wasn't enough, as a third basis for denying plaintiff's motion, both city and county defendants argue that the disputed discovery requests are well within the scope of permissible discovery in this case, and on their face do not support a protective order. Too much of the court's time has been spent reviewing the record and plaintiff's improperly filed motion. Because no written discovery requests are pending and plaintiff's motion is denied on procedural ground, the undersigned declines to reach the merits of the motion for protective order. So the basic things is the protective order was declined. Plaintiff is forewarned, i.e., you get no second chances. Pro se litigants are not excused from complying with all applicable rules of procedure and all orders of this court, including standing orders. Should plaintiff file an improper discovery motion or fail to fully comply with the same civil rules and procedures in the future, he may be subject to sanctions. Now, don't get all hot and bothered. If the court orders sanctions and he doesn't pay, then the court might issue further sanctions, bench warrant, or whatever. It ain't going anywhere. It ain't going anywhere. I think at best the court might dismiss the case with prejudice if he fails to pay the sanctions, and that's about it. I don't get excited over this. Based on the age of the case, parties are directed to file their joint Rule 26F report not later than 14 days from the date of this order. And within 3 days of the date of this order, plaintiff must contact all defense counsel in writing, via email, and list not fewer than four times on weekdays during which plaintiff is available to be conferred telephonically for Rule 26F conference. The reference dates must allow sufficient time for compliance with paragraph 3 of this order. That is this one. And any specified times must fall between the hours of 9 a.m. and 5 p.m. Eastern Standard Time. Court doesn't care that you're on Pacific time. 6 a.m. and 2 p.m. Good luck, Chile. So that is it on that. The other thing is that once again, apparently, Chile is making some allegations or assertions of law that police cannot solicit a trespass. Now, I have never seen anybody point me to any statutes that say this, any rules like California Code of Regulations or Federal Code of Regulations. I've never seen anybody point me to any statute, rule, any order of a court, any opinion of an appellate court. I've never seen anything pointed to me that supports this. And one question you have to ask yourself is, when Chile says that the police can't solicit a trespass, what happens if they do? Well, first of all, what is the definition of soliciting a trespass? That's question number one. Question number two is, if they do it, what's the penalty? Because the penalty is going to tell you a lot about what Chile thinks the origin of this particular rule is. If it's exclusion, if it's evidence exclusion, then it's based on some provision of a Constitution. If it's criminal charges for the cop, then there's going to be some penalty associated with it, like jail time, misdemeanor, felony, fines, whatever. But there is zero cases that I can find, and I spent about a half hour today looking for them, and I've spent time in the past looking for them. There are no cases that say that a cop can't solicit a trespass. And imagine this, if you will. What Chile is essentially saying is that a cop can't walk up to a citizen and say, did you want this guy criminally trespassed? Like, what happens if if the cops get called, like a shop owner calls the cops and says there's a guy over here who's on my property and I want him trespassed, and the cops show up and they walk into the shop and they say, is it that guy? Is it that guy that you want trespassed? Oh, is that soliciting a trespass? So what is it? What are the ramifications? What are the consequences of the cop? He can never point one out. A quick and dirty guide. If someone says the Supreme Court said X, if they don't cite the case, i.e. by a full case name and not just, State versus Smith or something that like you'll never be able to find it. There's like 5 million of them. If they can't give you a citation, then it's bullshit. They're talking out their ass. All right, now we're going to do the humiliation ritual where I will read some because, well, I can. All right, we're going to do this right here. 8:30. It is 8 o'clock right now. What's the pants situation, Big Daddy? I already showed you. There are none. Good afternoon. Good evening, Johnny Bravo. What's up, my friend who annoys me, but I still like you? What's up, my friend who annoys me, but I still like you? Your grammar annoys me, but I'm glad you like me, I guess. I don't know. Kim Working says, Burby. Kim Working. Howdy, sharpshooters on power scooters. 34th Street. 34th Street. 35th Street greets. 35th Street. Wow. Rival gang. But that's all right. You're still cool in my book. Oh, Merb. You know just how to give me an underpants tent. You betcha, big boy. Merb. Poor little chili. Hey, coded. Yay, go Merb. 54th Street. I'm moving up. 34th Street? No, son. I'm up to 54th Street now. MERB. Good evening, sir. How are you and your Cox? You'd have to buy me dinner to find out. Thanks, Merb. Really looking forward to your comments on this one. Well, I've given them to you now. There you go, live. When Governor Castro is spreading propaganda. I'm sorry, I don't subscribe to him, so I couldn't tell you. Hi, Merby. Hi, Patrick. As a constitutional laws scholar, I approve this live stream. Well, I approve you approving this live stream. Lil delete. Super necessary human Decastro. You are truly magical delete laws being in two places at once. He is. I hope that too. Merby silenced the cock. I never would do that. I'm just that awesome. Chili's going to get the chair for sure. I don't think he's done anything that warrants a death penalty. But maybe he's playing musical chairs and I just don't know it. So good luck to him in that endeavor. Is that Chili squealing in the background? No. Chalet just needs a real man in his life. I happen to know somebody who's a real man. Ah, yay. Cock alert. Chili's a 20-year LOL scholar. I never heard that one before. Bring on the roosters. Are you king shaming me? And a doodle do. Nice cock. Thank you, sir. And I think that's a cock emoji. And do. By the way, C. Anderson is amazing. Well, I'm glad you like him. He writes a good brief. I'll give him that. I haven't really found much to criticize him on. He seems like he's a competent attorney. He seems like he does his research and finds cases to support his arguments. And and it doesn't hurt that he's going up against Chili and Floyd Wallace. I mean, when you're looking at the comparisons, he's not going up against, one of the greats or anything like that. He's going up against Wallace and Decastro. So, and do it again was me, Merb. Well, congratulations. Merb, want to try keeping your cock quiet? Well, why don't you stick it in your mouth and that'll keep it quiet. Blame wolves? Okay. That's it. I'm driving up there for a cockfight. Cockfight! And Ford truck guy? That's right. Ford trucks. Built Ford tough. #1 selling truck in America. Hell yeah. Merb is obnoxious cock. You're not the first person to say that. I will cock block now. Well, that's too bad. Hush, babies. Please, no more, please. Well, Merb choking his chickens. Or cocks? I don't know. Smiles, karma's going to find chili. I don't believe in karma. A lot of really bad people get really rich and die really old. I don't believe it works. Sorry. And remember the song, Only the Good Die Young. I told that chili come sue the whiz. I have no idea what that means. Patrick Wieners. Wieners. Is it so wrong for people to get a little joy from thinking about Chili sitting in jail? I wouldn't wish that on anybody. Is it wrong? They call that Schadenfreude. Is it wrong? I mean, I guess that would depend on your own personal moral decisions. Like if you ended up in jail, would you want people celebrating it? That's kind of where I look at it from. How would I want to be treated? The old golden rule: do unto others as you would want done unto you. Right? I only wish Chili his own energy against him that is fair. Chili hurt people. Believe me, I only fight evil and I foe it with righteousness. I used to play this video game back in like the 90s. It was Baldur's Gate, and there was a character in it, Minsk, with his space hamster Boo, his miniature giant space hamster Boo. And readers, you kind of remind me of Minsk. He has been repping a lawyer. Okay, good to hear you. Good to read you, Lurker One. Let's be honest. Is that a lesbian joke? Let's be honest. Lesbian joke? I get it. Mandating him to have a psychological evaluation may be more appropriate than jail. No one's sending him to jail, bro. On the resisting arresting, if his lawyer is half as good as his lawyer should be, doing nothing but little misdemeanors like that, he should get Chili just time served, and maybe like some probation and a fine, maybe some community service or something like that. I wouldn't expect more jail time. I would be surprised if he got more jail time, honestly. What's his advice worth? I don't know. Tell us, Frauders Exposed. Well, he can't tell you on this channel anymore. I'm sorry to say that. I've taken a zero tolerance to stupidity. Too much of my time has been taken up by really fucking stupid people thinking that their opinions mattered. Way too much of my time. And you have free speech. You could go speak anywhere else, but I'm not giving you any more of my time. Today is my last day as a teacher. Sad in a good time. Well, I am sad for you. It sucks to stop doing what you love. And I know you're in England where they have like different retirement laws and requirements, but I tell you what, I am never going to retire if I can help it. They're gonna haul my carcass out of my office when I die, because it just seems like every time people retire, or whatever. Well, every time, but a lot of times, like right after they retire, they start going downhill. And yeah, I mean, you got to keep your mind sharp. You know what I'm saying? MEB 500 per hour. Anything you're doing at 500 per hour, you probably should slow down. Do a shotgun with buckshot, not a 45. You don't want to mess up. And have to have your wife take care of you. Excellent advice. Listen to the man. He knows what he's talking about. I hope you have a great evening, Mr. 34th Street. And you too, Shiz. I hope you have a great evening as well. That's some great grammar, Mr. Stout. That's something that no one has ever said, unironically. I'm such an edgelord. Yes, I am the king of edgelords. I am the absolute king of edgelords, with smiles and a wave. I like it. Doesn't he allegedly beat women too? If you're talking about Stout, I don't really know. Don't really care. He's a fucking idiot with an opinion, and that's a dime a dozen on YouTube. I'm an idiot with an opinion, except the state of California and its infinite wisdom decided that I was competent to practice law. So, if you trust the state of California, I'm your guy. If you would rather have a ex-con drug addict who lives in his mom's garage, I mean, Stout's your man. I mean, Stout, and Stout. That's pro se litigants, man. He's got the letterhead to prove it. All right. LMAO. I got Merv's back. Only if you buy me dinner first, sir. I'm normally a top, not a bottom. So, maybe nibble on my neck a little bit. Got to get me in the mood for that. Usually not down for that. Yo, Mindhunter. I'm late, but worth the wait. That's what you tell all the ladies, right? No? All right. One chicken has been on camera all live stream. Can you show some of the other chickens this time? He's calling me a chicken. That's great. More than 80 times. All right. Hi, Linda Borum. She's skeet skelterin. Shiz skeet skelterin. I don't know what that means, but I'm sure it's important. Shiz, I'm surprised he's not on Mass and Cass. I don't know what that means. Oof, Boston burn. I think Anderson is sending an I see you to Chile. Maybe. I think he's doing it to try to head off some of the bullshit motions he knows Chile's going to file. I think he's trying to head that off at the pass more than an ICU. Yeah. Stout is a pud puller. Well, aren't we all? Like, if you're a dude, you've had your dick in your hand more than once. Like, let's be honest. All right. Hey, Mark, I hear they need a fake lawyer at the Welsh Snooze Network. Ha! Ha! I have not had nearly enough alcohol to make that funny. I'm sorry, Coded. He deleted his comments, so now mine doesn't make any sense. Well, I think I banned him, and I think that deleted his comments. So it wasn't him. It was me. There was a long time where I didn't ban or block anybody. There was years. I started banning and blocking people this year because I suddenly realized that, like, I don't have a lot of time, and there's a lot of really shitty people who waste a lot of my time that could be devoted to better things, i.e. not shitty people. Shiz, I hope all is good. Anyone keeping score? How many losses is this for Chile now? Chile hasn't lost LVMPD yet. So, yet. He will. Oh, and he hasn't lost Ohio yet, but he will. Don't bank on winning discovery motions as winning. They're not dispositive. It's only the dispositive things that count. Non-dispositive things, you can lose all of them and still win the case. Will this stop Chile, Merb, or will he not be phased? I don't know. You'd have to ask Chile that. Chile lost the day he was born. Ouch. Whatever happened to the chiefy? The jefe? I don't know. Nice denied. Save face for a pequel. I just thought by tell Merb he has a good. To tell Merb I hope he has a good night. Then MC Mark was here entertaining everybody, so I lingered. Yeah, sounds like a song. Nider's shiz. Sweet dreams all. I'm making homemade brick clay. Like, what are you taking, bro? Like, you need to share whatever you're on with the rest of the class because it sounds like it's some pretty good shit. Howdy to you, guess who? Aw, tanks. Merb, I finally caught you live laughing. I guess you did. Yeah, we nice. We gave you another chance to make you look like shit. Huh. Flaccid penetration. Yay, harassing. Not responding, harassing. I'm in a case I know. Chile went from entertaining to boring and just embarrassing. Well, he's a one-trick pony. And what are you going to do? When your one trick ceases to be entertaining, what are you going to do? I smell bull poop. Okay. Jose Roberts, I agree. Chile is guess who doodle cakes. Excusable neglect. Not applicable. Then swallowed. Now to spit it out. Lol. Again, whatever drugs you're on, bro. Never a good thing when you prove to the judge that you are playing games. And a liar. And a liar. To stick it in his ass. He, she, it, you forgot they. Zer, Zim, whatever. I forget lots of them. You know, I try to hit the high points, and I'm assuming that the district judge, if that district judge has different pronouns, then that district judge can direct me what pronouns that district judge would like for me to use. And I will use them because I don't want to piss off judge. He likes that. Pyramid-shaped action. Merb, can you please go over Floyd's LVMPD lawsuit? You'll love it. I've glanced through it. It's basically a rehash of Chili's. It was useless. Oh my God, Floyd called me. He gave me $200. I believe you. You're the man, Merb. Glad to see you doing your thing and providing epic material for long drives. Anything for you and your long drives, sir. He was a good guy at first. I smell bull poop, $200. He did $25 8 times. I agree. A review of Chili practicing law in Floyd's trial would be awesome. There won't be a review of Chili practicing law in Floyd's trial. I guarantee you that. 100% will not happen. I was running a mission and helping people. Smile. They got to punish Chili. Merb tried to warn him. Chili's too stupid not to listen to Merby. Jesus Christ. Bro, calm down. Calm down. Merb sure did. And yes, the clerks talk and they talk about Chili. Whatever that is. Wow. This law scholar gig was working out about as well as his acting career did. He was the Black Power Ranger for one unaired episode, so that's more than I can say. More acting than I've ever done. Have you ever heard of Shit Express? I just increased the video quality from 144 to 720. You look fantastic. Thank you. I still don't like you, Paul, but it's nothing personal. I mean, it's entirely personal. But thank you for the compliment. Merb got a new burb. No. Same burbs. Is that a hawk I keep hearing in the background? We have lots of hawks out here, but I haven't heard one. Blah, blah, blah. My good name is cleared. Yeah. No, not cleared. Thanks again for the laughs. Oh, my pleasure. I think they want to call him more than a dunce cap. Probably. Merb's having entirely too much fun with this dramatic reading. Yes, I did enjoy it. Judicial ethics. Yes, they exist. Most judges have a lot of restraint. Most judges follow the judicial ethics and canons, etc. Hey, how you doing? I wonder if Chili started crying when you read this. I don't know. He probably smoked a joint. That's what I think he would do. I don't think Chili has stopped crying. This is awesome. You're awesome. I'm just here for the cock. Yeah, all right. Chili's capable of viewing anything about him in a negative, incapable of viewing anything about him in a negative light. Somehow his brain will read this as a victory for Chili. Well, what is that a Trump thing? Any press is good press. Bad press is still press, and so any press is good press. Whatever. Chili gets bitch slapped. That is great. He clearly, after I found out, he did. Hello, all. Hello. Lol. Chili and Floyd are perfect for each other. Is Floyd gay? I didn't guess Floyd was gay. I mean, maybe they are. I mean, a little bit of cream in the coffee. Maybe. I assume Chili's a bottom. He strikes me as a bottom. I could be wrong. A lazy bottom, by the way. Facts. Hey man, how you been? Don't skip footnote 10. Go back. Oh, I probably did. Sorry, I wasn't looking at chat. How good are you? Well, let me see. Did I skip footnote 10? No, I'm not going to go over footnote 10. So, no, I'm not going to go over his phone number. But thanks. Just listening to Chili's reality check. I'm sorry we're watching this. So basically, he lost this lawsuit and it will be dismissed. I don't think none of them are currently set to be dismissed, or none of them we can be certain are going to be dismissed at this point yet, other than the Massachusetts one. I mean, who knows which way the judge is going to go. And the judge could give them leave to refile still, file an amended complaint or whatever. So, I mean, there's lots of wiggle room. Even Chile has to get that this judge is pissed and he better be careful. Yeah, he should. He really should. I mean, the judge was very explicit as the judge could be, and still maintain the judicial kind of decorum about it. Hopefully he gets one very soon in Floyd case. Chitler supposedly has over 200K subs, but can't really have more than 200 live viewers. Well, maybe they're in different time zones. His game's finally caught up to him. Basically, being called a dumbass by a judge is quite an achievement. Yeah. I mean, there are a lot of dumbasses going in front of judges every day, and if the judge actually takes the time to point out to you that you're, what was it, sheerly incompetent or clearly incompetent or something like that, sheer incompetence. Yeah, you're incompetent, you're a liar, and you're game playing. Like, dude, like you win nothing. Can court sanction at some point because of judgment against him? That doesn't make sense. Courts don't sanction because of judgments. Chili, you can eat my shorts, Judge. Probably he would say that, and that would not work well. All the fraudsters claim that, not just Chili. We're talking about the can't solicit a trespass. Yeah, completely baseless, grounded in nothing. Zero basis for it in statute or case law. So I don't know why. People will pay for chicken shit. No one will pay for chili. That is true. People use chicken shit as fertilizer. The Schadenfreude is beautiful. They lose their qualified immunity. No, they don't. That's waste half hour. Well, I'm glad to have wasted a half hour with you. It was fun. Of course, cops can indeed solicit a trespass under Chili's definition. I don't know really what Chili's definition is. It'd be interesting to learn it. Merb, are sanctions always a financial penalty? There could be sanctions like discovery sanctions, and like if you refuse to produce some set of discovery, the court could sanction you by saying that that the jury is going to have to deem whatever that is as being against your position. Like if they say, show us the deed, and you're like, no, I'm not going to show you the deed. Well, then the court could, in theory, issue a sanction saying, well, I'm going to sanction you by making sure any jury instruction includes an instruction that the jury will have to assume that deed was, whatever, against you, whatever your position was. Or there's issue sanctions, there's discovery sanctions, issue preclusion, claim preclusion, evidence preclusion, and money. There might be other things. You might be put on like a vexatious litigant list. I mean, there are other things, but it would probably be money. Another masterpiece. I would not think anything I produce is a masterpiece. All my shit is just randomly slapped together because, well, that's all I get paid to do. Of course, the police can do that. Think practically. Police often advise people as to what should be done in a situation. Any salvator says they can't do it as an idiot. Yeah, it's baseless. Chilita can solicit a sex act from the police. His arrest record or his arrest recording shows it. F Chili, okay. Chili might be into that. Hopefully, one of the sanction options is the bailiff brings a person in and kicks them in the nads. That's a Cheech and Chong skit, I think. We should all just go from Fraudicit channel to Fraudicit channel and comment whatever their last community post is a D type. There's no such thing as soliciting a trespass. I don't want to brigade anybody. I don't recommend you brigade anybody. I mean, you're not going to convince anybody by doing that. 408 letter sent to AutoZone. I don't know what that means, but congratulations. Fuck you, lady. That's what friends are for. Okay. I have, sure, dyslexia. Okay. Tipsy? Not really. I have had some, but I'm not really tipsy. Ironton here. Hi. Well, hello, Ironton there. Are you the whole city or just a small subset of it? Hi, Michelle. Do you want to sit together in your underwear with me, Merv? Maybe. 20-year cringe situational law scholar. Good stuff. Next episode needs more alcohol. I will work on that. I can't really get drunk during the week, obviously, because I gotta hit the road at 7 o'clock in the morning because freaking clients expect me to actually do stuff for them. Merb, can you also address the claim that Chili makes when he says he can't be trespassed from private property when acting as a journalist? That's bullshit. That is pure bullshit. He would need to cite some sort of a claim for it. I don't see why a private party would not be able to trespass you for any reason or no reason. I mean, there are some like the Equal Rights Act, I think, for like places that provide that participate in interstate commerce, like inns and stores and bars and things like that. They can't trespass you for things based on race, color, gender. No, race, color, sex. I think age is one of them now. They can't trespass you for those things, but nothing. There's no law saying that they can't trespass you for First Amendment issues, except for prune yard. So like some place like California, where prune yard versus Robbins, like you can't get trespassed from a mall, from the common areas of the mall for First Amendment things there. But generally speaking, the general rule is that you can get trespassed from private property for any reason or no reason, and claiming that it's over your First Amendment right. Well, the First Amendment protects you from the government, not from private parties, and there's no special right of access as a journalist. So, and there's specific Supreme Court case law on there's no special right of access as a journalist. What's that one? KQED. There's one where KQED wanted to go in and film in a prison. It was a Supreme Court case, KQED versus somebody. It was the California Department of Prisons. And Supreme Court said that there's no special right of access for journalists. You're awesome. You're so incredible. Thank you for everything. You're so funny. I'm your number one fan. Are you my number one fan, though? But I appreciate it. Thank you. Laughing, LMFAO. Is that Don Boone? I don't know. You, good sir, deserve an alcoholic beverage and a blowjob. Pay you for your old sweaty, dirty underwear. I'll pay top dollar. Hit me up. DM me. He didn't win and break his losing streak, right? I don't believe he's ever won. Merb, who's wearing underwear 34th Street for life bitches? I don't know. I'm not. Yes. Press has no more rights than any person. Government can trespass press for smelling bad. Press has no more rights than any person. Government can trespass the press for smelling bad. Well, I mean, that's a very general statement. And so I'm going to say you need to put a lot of asterisks by that. And they can't trespass the press if they're not trespassing the general public. So I'm just going to go with, I think your statement is overbroad and incorrect. You made my night. You made my nothing, really. But thank you. Again, I appreciate you. Thank you for answering my question in such detail. You're welcome. First and last time watcher, all I hear is a dog whining or a bird, and then I'll start hearing a rooster. Am I the only one bothered by these sounds? Well, thank you for letting us know. I would never have known to miss you, but now that I know that you've been here and you've told me graciously that you're leaving, now I miss you and I feel bad, and I'm going to eliminate my chickens and roosters for you. Oh, wait, I'm lying. What kind of dinner do I need to buy to see your frog on the lily pad? DM me. We'll figure something out. There's merely smelling, then there's dripping liquid. Okay? You gave me exactly what I paid for. And that's all I intended to do. Dude got trespassed from library for stinking. Right. And with that, I will say good night. Thank you for coming to my TED Talk, and have a great evening.